The confrontation between Congresswoman Jasmine Crockett and legal strategist Kash Patel did not emerge from thin air. It was the culmination of months of tension surrounding the Voting Rights Bill, a piece of legislation intended to fortify federal oversight on election integrity and protect minority voting access. The bill aimed to restore key provisions of the Voting Rights Act of 1965, gutted by the Supreme Court's decision in Shelby County v. Holder, 2013. At its core, the debate revolved around one question: how far should Congress go in regulating elections to guarantee equality? For many, the bill represented a renewed promise, an effort to secure voting access for marginalized communities facing new barriers in the digital age: gerrymandered districts, aggressive voter ID laws, and localized suppression tactics disguised as fraud prevention. Yet for others, including Kash Patel, it symbolized federal overreach, an infringement upon states' rights, and the traditional balance of powers enshrined in the Constitution. Patel, once a senior official in the Trump administration and a self-proclaimed defender of constitutional purity, had long argued that states, not the federal government, should control the mechanics of elections. His stance rested on an interpretation of the Elections Clause Article 1, Section 4 of the U.S. Constitution, which grants state legislatures the initial authority to determine the times, places, and manner of holding elections. Patel insisted that Congress's power to make or alter such regulations was corrective, not creative. In his words, Congress could only intervene when states failed to act, not to establish sweeping nationwide standards. But Jasmine Crockett, a freshman congresswoman and former civil rights attorney, saw things differently. Her life's work had been spent litigating cases where state-level voting policies were used to disenfranchise communities of color. To her, Patel's interpretation of the Constitution was less about fidelity to the text and more about protecting entrenched political power. Crockett's courtroom instincts, honed through years of cross-examining hostile witnesses, turned what could have been a routine hearing into a national spectacle. The day of the confrontation, the House Committee on Oversight was packed beyond capacity. Cameras rolled as the tension built. Patel, polished and confident, repeated his talking points. This bill is a violation of federal restraint. It substitutes national mandates for local wisdom. The founders never intended such interference. His cadence was crisp, his tone professorial, the kind of delivery that once made cable networks adore him. Crockett sat quietly, reviewing notes filled with color-coded tabs and footnotes from Harvard Law Review articles. Then, when given her 5 minutes, she did not start with a question. She started with a quotation. "Mr. Patel," she said, "in 2011, you wrote in the Harvard Law Review that, and I quote, 'Congress possesses the plenary authority to ensure fair and uniform administration of federal elections.' That was your writing, correct?" Patel blinked. The room fell silent. It wasn't the quotation itself that stunned the audience, but its source, his own academic past. He had, a decade earlier, argued precisely the opposite of what he was defending that day. The quote, carefully extracted from a paper co-authored by Patel when he clerked for a conservative judge, demonstrated not only a contradiction, but a transformation from a young constitutional idealist to a partisan legal warrior. Crockett had done her homework. The phrase, "brought the receipts," quickly began trending online. Within minutes, clips of the exchange circulated across social media with captions like, "Crockett ends Patel's career in 10 seconds." The sharp contrast between the two figures amplified the drama. Patel was a veteran of Washington's inner circles, a lawyer who had defended some of the most controversial executive decisions of the past decade, from the defense of aggressive surveillance programs to the rationalization of executive privilege claims shielding presidents from accountability. Crockett, on the other hand, represented a new kind of Democratic legislator, young, data-literate, unapologetically direct, and deeply rooted in civil rights law. The core of Patel's argument against the Voting Rights Bill was that it federalized democracy. He contended that, by imposing national standards for redistricting transparency, voter access, and digital election security, Congress would effectively strip states of their constitutional prerogatives. "Our republic was founded on local autonomy," he said. This bill undermines that principle by placing Washington bureaucrats in charge of local elections. Crockett's rebuttal, however, was not ideological. It was forensic. She didn't argue from emotion, but from evidence. She had compiled a line-by-line comparison of Patel's prior testimony in congressional hearings, his legal writings, and even media appearances, all showing that his positions on the limits of congressional power were inconsistent, bending with the political winds. Where Patel invoked the founders, Crockett invoked precedent specifically, cases like Ex parte Siebold, 1879, and Arizona v. Intertribal Council of Arizona, 2013, both of which affirmed that Congress holds broad supervisory power to protect the integrity of federal elections. The Elections Clause is not a suggestion, Crockett said. It's a safeguard. Congress was not meant to be a spectator while states suppress votes. The crowd's reaction reflected the gravity of the moment. It wasn't merely a clash of personalities but of constitutional philosophies. Patel's textual rigidity met Crockett's pragmatic realism. One saw the Constitution as a closed document frozen in 1787. The other saw it as a living instrument of accountability. Crockett's tone sharpened. "You cannot, Mr. Patel, treat the Constitution like a menu, picking and choosing which powers you recognize based on who occupies the Oval Office." The audience erupted. Patel leaned back, visibly flustered. In that single sentence, Crockett had captured what legal scholars would later describe as the heart of constitutional opportunism. Her critique was not merely about Patel's inconsistency but about the broader decay of intellectual integrity among political legal elites. Behind the spectacle, however, lay deeper implications. The Voting Rights Bill had languished in committee for months, blocked by claims of federal intrusion. Yet the Crockett-Patel exchange reframed the issue. It wasn't about states' rights versus federal power. It was about whether constitutional interpretation could remain principled when filtered through partisan loyalties. In the days following the hearing, major newspapers ran op-eds praising Crockett's precision and composure. The New York Times called her cross-examination a masterclass in constitutional accountability. Conservative outlets predictably accused her of grandstanding, but even they acknowledged Patel's stumble. As one Politico columnist put it, Crockett didn't just win the argument. She exposed the double standard that defines Washington's legal discourse, one where principles bend when power changes hands. The clash marked a symbolic transition in American politics. From the era of polished legal punditry to an age where evidence, receipts, and intellectual honesty could outweigh status and pedigree. Patel, once revered as a disciplined legal thinker, suddenly faced a credibility crisis, and Crockett, propelled by viral momentum, became an unexpected constitutional voice for a generation skeptical of legal elitism. By the end of that week, "Number Crockett effect" trended on Twitter. Law students dissected the transcript in seminars. Even former prosecutors privately admitted that Patel walked into that hearing like a professor and walked out like a defendant. But this was only the beginning. What made the confrontation truly historic was not the embarrassment Patel endured. It was the exposure of how far partisan actors were willing to distort constitutional reasoning to serve temporary political ends. The moment illuminated a deep fracture in American legal culture, one between those who treat the Constitution as a shield for the powerful and those who see it as a promise to the governed. When Congresswoman Jasmine Crockett uttered that now iconic phrase, "You cannot treat the Constitution like a menu," she didn't just win a soundbite. She executed one of the most technically precise rhetorical takedowns in recent congressional history. But what elevated the confrontation from political theater to constitutional scholarship was what came next. The unveiling of receipts, the meticulously documented evidence showing that Kash Patel's interpretation of the Constitution had shifted not because of new facts, but because of new political allegiances. The phrase, "brought the receipts," originated in internet culture, referring to the act of backing one's claim with indisputable proof. In the Crockett-Patel exchange, it meant that every accusation was anchored in Patel's own words, published under his own name, in prestigious legal forums. Crockett wasn't arguing from opinion, she was citing precedent, demonstrating contradiction, and methodically dismantling a legal career built on selective constitutionalism. At the core of her strategy were two key battlegrounds: the scope of Congress's authority over elections and the boundaries of presidential impeachment power. Both were deeply constitutional, both politically charged, and both revealed Patel's intellectual inconsistency. Congress's power over elections. Crockett began by revisiting Patel's earlier writings. A decade prior, Patel had authored a detailed analysis in the Harvard Law Review titled "Safeguarding Federal Elections: The Supervisory Role of Congress." In that article, Patel argued that the Elections Clause granted Congress broad, plenary power to regulate the conduct and fairness of federal elections. He had cited Ex parte Siebold, 1879, and Smiley v. Holm, 1932, to assert that federal authority was essential to prevent fragmentation and corruption in electoral administration. But during his testimony before the committee, Patel declared almost the opposite, that the Elections Clause is narrowly corrective and never intended to permit Congress to dictate state election procedures. He claimed that national voting standards would dilute local sovereignty and violate the spirit of federalism. Crockett's team had predicted this pivot weeks in advance and prepared accordingly. As Patel tried to explain his reasoning, Crockett interrupted him gently but firmly. "Mr. Patel, are you suggesting that the Supreme Court misread the Elections Clause in Intertribal Council of Arizona when it reaffirmed Congress's power to impose uniform voter registration standards?" Patel hesitated. "No, I'm suggesting the court misapplied the principle of state autonomy." Crockett nodded slowly, then opened a binder. "Interesting, because in your 2011 testimony before the Senate Judiciary Committee, you described that very case as a well-reasoned affirmation of congressional supremacy in regulating federal elections. That's your quote, correct?" The silence was brutal. Patel attempted to deflect by citing context, but the damage was done. The contrast between his past and present words was irrefutable. Crockett's tactic was surgical. She used Patel's own intellectual lineage as the weapon. Observers later noted that this method reflected the precision of cross-examination rather than debate. She wasn't engaging in abstract theory, she was exposing motive. Patel's earlier writings defended federal oversight when his political allies were out of power. Now that the same oversight threatened his party's advantage, he called it tyranny. Crockett framed the contradiction as evidence of constitutional convenience, a term that would soon dominate academic commentary. She stated, "Constitutional consistency isn't optional. You don't get to reinvent the founders' intent every election cycle." Her words resonated because they reflected a larger truth, the erosion of principled legal interpretation in favor of political expediency. Crockett was articulating what millions of Americans sensed that many so-called constitutional debates were, in reality, partisan disguises. Patel's defenders argued that his evolution reflected nuance, not hypocrisy. But Crockett preempted this argument by reading a second citation, a 2015 radio interview in which Patel said, "Anytime Congress regulates elections, it is acting squarely within its enumerated powers. The danger is not federal power, the danger is its neglect." The contradiction was devastating. Patel's previous insistence on congressional assertiveness now stood against his current denunciation of it. Crockett's receipts expose not just inconsistency, but opportunism. 2. The impeachment clause and abuse of power. If the first phase of Crockett's strategy revealed Patel's elasticity on election law, the second exposed his selective interpretation of impeachment, the constitutional mechanism for checking presidential abuse. In 2019, Patel had appeared on multiple media platforms arguing that impeachment required a clearly defined crime. According to him, allegations of abuse of power or obstruction were politically weaponized categories, not recognized under Article 2, Section 4 of the Constitution. Yet, Crockett unearthed a 2006 Law Journal article Patel co-authored titled "Abuse, Betrayal, and the Meaning of High Crimes: Revisiting Impeachment's Historical Roots." In that piece, Patel had written unequivocally that abuse of power, even absent a statutory crime, constitutes an impeachable offense when it subverts the Constitution's trust. During the hearing, Crockett recited this line word for word. Patel tried to interrupt, claiming that paper was a student exercise. Crockett didn't flinch. "And yet," she replied, "you've cited your student research in federal filings before, haven't you? Because it supported your earlier arguments. The standard changes only when the beneficiary of abuse changes." The tension was palpable. Crockett had cornered Patel into acknowledging that his interpretation of impeachment, the mechanism meant to constrain executive misconduct, had mutated to protect one administration and attack another. This wasn't an academic dispute. It was an ethical indictment. Patel, visibly frustrated, retreated into the familiar rhetoric of political witch hunts. Crockett didn't respond emotionally. She stayed clinical, almost cold. "You have a remarkable talent, Mr. Patel," she said, "for treating constitutional principles like campaign slogans, useful when convenient, disposable when not. That line, clipped and uploaded online within minutes, became the second viral quote of the hearing. Commentators on both sides recognized the underlying message. Crockett wasn't just challenging one man's inconsistency. She was questioning whether constitutional law itself had become a partisan accessory. 3. Tactical precision. Law as language. Crockett's effectiveness stemmed not only from her evidence but from her command of language. She used brevity as a blade. Instead of drowning Patel in rhetoric, she let his contradictions speak for themselves. Every citation had a timestamp, a publication, a URL. In an age of misinformation, this precision carried moral weight. It transformed legal debate into a confrontation with documented reality. Observers described her tone as controlled aggression. She didn't shout, didn't mock, didn't gloat. Her strategy relied on contrast, calm facts against defensive bluster. The more Patel insisted on interpretation, the more she anchored him to documentation. It was an asymmetric battle she fought with archives, he with assertions. Legal scholars soon began dissecting her method. A symposium at Georgetown Law labeled it the Crockett Doctrine of Evidentiary Accountability. The core principle: public argument must be traceable to verifiable intellectual commitments. In other words, you can't reinvent your jurisprudence every time the political winds shift. Her approach also exposed a growing tension in American constitutional discourse: the divergence between scholarly integrity and performative partisanship. Crockett represented a new generation of lawmakers, fluent in both law and digital accountability, capable of calling out inconsistencies not just in real time, but with hyperlinks. 4. Broader implications. The collapse of legal credibility. Patel's downfall in that hearing was more than personal humiliation. It illuminated a systemic rot, a culture in which elite lawyers use constitutional rhetoric as political armor. Crockett's receipts demonstrated that arguments presented as timeless principle often collapse under historical scrutiny. Her exposure of Patel's contradictions resonated far beyond the committee room. Law professors began assigning the transcript as a case study in rhetorical ethics. Editorial boards debated whether partisan lawyers could still claim to speak for the Constitution at all. Even conservative scholars privately admitted that Patel's defense had been a masterclass in self-contradiction. The exchange also re-energized debate over the voting rights bill itself. What had previously been dismissed as a partisan exercise suddenly gained legitimacy as a constitutional imperative. Crockett reframed the bill not as federal interference, but as constitutional guardianship, the execution of Congress's duty to ensure equal access to democracy. Patel's credibility, however, never fully recovered. In subsequent appearances, he tried to clarify his context, but every attempt only drew more attention to Crockett's receipts. Cable panels replayed the clip with split screens of his past quotes. The damage was archival, permanent, factual, unspinnable. V. The legacy of the receipts moment. By the end of that week, Crockett's performance had transcended politics. She had pioneered a model of congressional inquiry that combined legal scholarship with digital age accountability. Every citation she used could be verified by the public, every argument linked to a traceable record. It wasn't just transparency, it was an intellectual audit. Political analysts dubbed it the Crockett method. Confront ideological inconsistency not with outrage but with documentation. In an era when partisanship often substitutes for logic, this method restored a lost discipline to public argument. The phrase "brought the receipts" became shorthand for truth-based confrontation. Activists used it to challenge hypocrisy. Academics cited it to defend methodological rigor. And journalists, perhaps for the first time in years, began treating congressional testimony as something worth fact-checking in real time. But the deeper power of Crockett's strategy lay in its philosophical message that facts are not partisan and principles are not seasonal. She had shown that the Constitution's integrity depends not on who interprets it, but on whether interpreters respect their own precedents. Patel's defeat wasn't in losing an argument, it was in losing coherence. Crockett didn't out-talk him, she out-consistency'd him. The confrontation between Jasmine Crockett and Kash Patel did not fade when the cameras stopped rolling. It reverberated far beyond the congressional hearing room, igniting debates across law schools, newsrooms, and even the Supreme Court chambers months later. What began as a clash over a voting rights bill evolved into a national reckoning on the integrity of constitutional interpretation and, more broadly, the moral cost of partisan legalism. The political world quickly labeled it the Crockett effect. the phenomenon in which meticulous evidence and intellectual consistency could pierce through the noise of partisan rhetoric. In an era where shouting often replaced reasoning, Crockett's calm, fact-driven dissection of Patel's contradictions stood as a reminder that truth still had tactical power. The shockwave across the political landscape. Within 48 hours of the hearing, clips of the exchange dominated television and social media. Hashtags like #Crockett Effect and #Constitution Not Convenience trended across platforms. What struck viewers wasn't just that Patel had been caught contradicting himself, it was that a young congresswoman had done what many veteran politicians failed to do: force accountability through evidence. The impact was immediate. Public support for the voting rights bill surged by nearly 20 points in national polls. Commentators who had previously dismissed the bill as a federal power grab began reframing it as a constitutional duty. Crockett had effectively rewritten the narrative. This wasn't Washington invading state affairs, it was Congress fulfilling its constitutional responsibility to protect democracy itself. Major newspapers mirrored this shift. The Washington Post editorial board wrote, "Crockett reminded the nation that fidelity to the Constitution means fidelity to its purpose, not convenience." Her performance dismantled the illusion that constitutional originalism equals neutrality. Meanwhile, conservative pundits struggled to contain the fallout. Patel's allies attempted to paint Crockett's attack as performative, but their defenses backfired. Every denial only drew more attention to the documented inconsistencies she had revealed. Cable news segments juxtaposed Patel's past quotes with his current testimony in split-screen montages, visual proof of hypocrisy that no spin could erase. What began as a single committee hearing soon reshaped the broader national conversation about how lawyers and politicians invoke the Constitution. For years, the term constitutional conservative had served as a shield for ideologues seeking moral legitimacy. Crockett stripped that veneer. She exposed that many self-described constitutionalists were not defenders of principle, but opportunists of power. 2. Intellectual fallout. Integrity on trial. In law schools across the country, professors began using the Crockett-Patel transcript as a case study in constitutional ethics. One Georgetown seminar titled "Law and Integrity in the Age of Polarization" analyzed how Crockett's argumentation represented a new standard of evidentiary rigor. She had turned the committee hearing, typically a theater of partisan posturing, into a courtroom of facts. Legal scholars coined a term: constitutional opportunism, the tendency to reinterpret founding principles according to transient political goals. Crockett's cross-examination had laid bare this intellectual disease. Patel was simply its most visible symptom. The academic community responded with both fascination and discomfort. Some conservative jurists admitted privately that Patel's contradictions mirrored a broader institutional problem. Alan Dershowitz, the famed constitutional scholar whose evolving interpretations had inspired Patel's career, became an unintentional symbol of this crisis. For decades, Dershowitz had oscillated between defending presidential power and condemning it, depending on the occupant of the White House. Crockett's evidence-based method implicitly rebuked that pattern. In one fiery lecture at Yale Law School, Professor Henry Braverman summarized the moment. What Crockett exposed was not just Patel's inconsistency, it was the collapse of intellectual honesty among legal elites who confuse advocacy for analysis. The Constitution is not supposed to have a party. Her questioning had triggered something larger than a viral clip. It had revived a dormant conversation about moral coherence in American jurisprudence. Law, Crockett reminded the nation, is not just a contest of cleverness. It is an oath to consistency. You cannot claim reverence for the founders while reinventing their words to fit your political tribe. 3. The political repercussions, redefining accountability. Politically, the hearing altered the trajectory of the voting rights bill. Before the confrontation, the legislation had stalled in committee, trapped in procedural purgatory. Afterward, it gained bipartisan momentum. Public petitions flooded congressional offices. Activist groups used Crockett's quotes as rallying cries. The Constitution is not a menu, it's a mandate. Federal power is not tyranny when it protects freedom. Even moderate Republicans began reconsidering their positions. The spectacle of Patel's collapse made continued opposition look intellectually dishonest. Within 3 months, a revised version of the bill passed the House with surprising bipartisan support. The Senate, long the graveyard of reform, followed suit after a series of public hearings where scholars cited Crockett's receipts as evidence of the bill's constitutional soundness. Political scientists later called it a textbook example of argument-driven momentum, when a single display of clarity reshapes legislative probability. Crockett's confrontation had not merely embarrassed an opponent, it had altered the probability calculus of democracy. IV, the Supreme Court echo, the circle completes. The ultimate validation came several months later, when the Supreme Court heard Reed v. Alabama Commission on Elections, a case challenging the new voting rights bill on constitutional grounds. Ironically, the conservative legal team opposing the bill cited arguments first developed by Kash Patel. They argued that Congress had exceeded its constitutional bounds under the Elections Clause, invoking Patel's previous writings as authority. But in a stunning twist, the court's majority opinion written by Chief Justice Roberts rejected that claim, citing not Patel's recent statements, but his earlier writings, the very ones Crockett had used to expose his inconsistency. In a footnote that became historic, Roberts wrote, "Even Mr. Patel, in his 2011 analysis, acknowledged that Congress retains plenary authority to regulate federal elections in pursuit of fairness and integrity. That principle remains as true today as it was then. It was poetic justice." The same intellectual foundation Patel had once built and later disowned for political expediency became the legal cornerstone of a Supreme Court decision affirming Congress's constitutional authority. When news of the ruling broke, journalists dubbed it the Crockett Echo. For the first time in modern history, a congressional cross-examination had directly influenced the language of a Supreme Court opinion. It was a vindication not only of Crockett's argument but of her method, consistency as power. V. The Crockett Effect, a cultural paradigm shift. The Crockett Effect soon transcended the world of law and politics. It became shorthand for a broader principle of accountability in journalism, academia, and activism. To Crockett, someone meant to confront hypocrisy with their own documented record. Students on campuses began using the term playfully, "Don't get Crocketted." Media commentators described her as the antithesis of performative politics, a leader who valued proof over posture. In interviews, Crockett remained humble, often redirecting credit to her legal training. "Preparation is my protest," she said on Meet the Press. "The Constitution doesn't defend itself. It requires people willing to remember what it actually says." How? That phrase, "preparation is my protest," became the unofficial motto of a new generation of legal activists. Workshops and think tanks sprouted around the idea that civic literacy and evidentiary rigor were the best defenses against political manipulation. Crockett's rise also redefined the image of the modern lawmaker, young, data-driven, and unafraid to challenge hierarchy with footnotes. She blurred the boundary between legislator and litigator, proving that one could fight disinformation not with outrage but with archival precision. V. Legacy. Principles outlast power. In the years following the confrontation, the Crockett-Patel hearing entered American political folklore not merely as a viral clip, but as a constitutional turning point. Law students studied it alongside Marbury v. Madison and Brown v. W. Board of Education for its demonstration of how principle can triumph over pedigree. The confrontation also left a scar on the culture of Washington legalism. No longer could partisan experts invoke the Constitution without facing the question, "Do your past words agree?" The fear of being Crocketted introduced a new kind of self-discipline into public argument. Patel, once a fixture on television panels, faded into relative obscurity. His reputation as a constitutional scholar never recovered. Yet, paradoxically, his earlier writings, the ones he tried to abandon, became his enduring contribution to the very cause he opposed. History has a cruel symmetry. The words that once served his ambition became evidence of his contradiction. For Crockett, the moment transformed her from a promising legislator into a constitutional conscience. She continued to champion reforms in electoral fairness, judicial ethics, and campaign transparency. But more than any policy victory, her legacy rested on a single, unshakable idea that the Constitution's meaning does not bend to power, but power must bow to meaning. 7. Conclusion. The Constitution is not conditional. The Crockett-Patel confrontation stands as a moral parable for modern governance. It proved that the greatest threat to the Constitution is no